Hello everyone, my name is Aurelia Vement. Welcome to this webinar on practical, legal and regulatory considerations from an AML perspective for the investment fund industry. A fascinating topic which is not without its hurdles. We will endeavor to guide you through the process, highlighting elements deriving from experience of advising clients in this respect. I am pleased to be joined today by my colleagues, which I will introduce right now. So Giulia Brucese, Senior Counsel in the Investment Fund team, Chris Soterio, Senior Associate in the Investment Fund team, and Mélanie Poirier, Managing Associate in the Banking and Finance Regulatory, Insurance and Reinsurance team. A little bit of housekeeping. So you are all on mute mode, and if you have any questions, don't hesitate to drop them in the chat. However, because we are endeavoring to keep this webinar sweet and short, so for 30 minutes, we will not have time to address these questions during the webinar. But if you have raised a question in the chat, we will receive it afterwards and make sure that we drop you a short email to answer your query. In terms of the agenda for today's webinar, we will first look at in-scope entities. So which are the entities which fall within the scope of application of AML CTF obligations? And so just AML CTF, when we're referring to that, we mean anti-money laundering and counter-terrorist financing measures. Then we will look at customer and asset due diligence, the roles of RR and RC, specifically for the investment fund industry, and last but not least, delegation arrangements and liability. And so I will now leave the floor to my colleague Giulia, who will explain the in-scope entities. Thank you very much.
Thank you very much, Aurelia, and good morning, everyone. To start with, it is important to identify the main legal source which outline the AML CFT obligations imposed on the in-scope entities. Additionally, and during this webinar, we will give you examples of which entities have to comply with such AML CFT obligation with a focus on investment funds and investment fund managers. The Luxembourg law of 2004 on the fight against money laundering and terrorist financing, as amended, is the predominant AML legislation in Luxembourg, transposing all relevant EU directives on the subject. On the screen, you can have an overview of the in-scope entities. And it is important to make a distinction between regulated and non-regulated funds. By referring to regulated fund, we mean UCITS, SIFs, SICAs, which are subject to the direct supervision of the CSSF and that are expressly mentioned in the AML law. They are required to comply with strict AML obligations. It is true that the AML law does not specifically refer to unregulated funds, meaning those funds which are not directly supervised by the CSSF, like unregulated partnerships or RAVs, but further guidance has been issued by Luxembourg authorities, which implies that some AML CFT obligations also apply to them. Unregulated AIFs, including RAVs, should notify the RC and RR appointment at the fund levels to the Luxembourg indirect tax authorities, as well as complete and designated AML questionnaire. Now I will hand over to Mélanie and Chris, who will give you an overview of what must be known about customer and asset due diligence.
Thank you, Giulia, and good afternoon, everyone. So now that we have established which entities in the fund industry are subject to the Luxembourg AML CTF framework, we will focus on the measures which these entities must implement to prevent and mitigate the risks associated with money laundering and terrorist financing. To do so, we will firstly go over the measures to be applied, both at your level and at the level of your customers or investors, the so-called customer due diligence measures, which I will present now, but also the measures to be implemented at the level of the assets held and managed by your funds, which my colleague Chris will present afterwards. So, as a fund or a fund manager, what measures are you required to implement to mitigate the risks of money laundering or terrorist financing? Firstly, you must perform a an overall risk assessment of your business and activity. What is the purpose of this assessment? Well, this assessment allows you to identify, assess, and understand the level of risks of money laundering and terrorist financing that your activities present. And therefore, based on this assessment, you will be able to mitigate these risks by adopting proportionate and adequate measures. In addition to evaluating your own overall risks of money laundering and terrorist financing, you're also required to carry out a similar risk assessment of each business relationships with your customers or investors by taking into account several risk factors, such as the location of your customer or investor, or whether your customer is a politically exposed person. This risk assessment of your business relationship is crucial. Why? Because this assessment will allow you to assess the risks of money laundering and terrorist financing that your client presents, and therefore to adapt the level of customer due diligence measures which you will apply to that customer or investor. For example, if you're faced with a customer or investor which presents a low level of money laundering or terrorist financing risk, simplified due diligence measures can be applied to that customer. However, if you are dealing with a customer or investor which presents a high level of risk of money laundering or terrorist financing, you will have to apply enhanced due diligence measures to that given customer. So the first measure is that your customers or investors must be identified and their identity verified. And the same obligation applies for any person purporting to act on behalf of your customer or investor, such as, for example, a proxy acting in the name and on behalf of your customer in the business relationship with you. In addition to this, you must also identify and take reasonable steps to verify the identity of your customers or investors' beneficial owners. Here, it is important to remember that the identification of a beneficial owner in a fund structure may prove to be difficult in practice, depending on the structure of your fund or the type of investors in your fund. And this is the reason why a case-by-case analysis must always be carried out to properly identify the beneficial owner of your fund. In addition to this, we just wanted to quickly remind you that as a fund, you are also required to register your beneficial owners in the register of beneficial owners. As part of your customer due diligence measures, you are also required to identify the purpose and intended nature of the business relationship with your customer or investor, which means that you must understand the reason why a given customer wants to enter into a business relationship with you. All of these measures must be carried out prior to entering into a business relationship or carrying out a transaction, but also on an ongoing basis. So now that we have gone through the measures which you must apply to your customers or investors, you may wonder who must be qualified as customer. And we can move on to the next slide for this. So a customer is defined as a natural or legal person with whom a business relationship exists or for whom an occasional transaction is carried out, including persons purporting to act on behalf of the customer. So as I've said before, this can be the proxy of your customer. And it must be noted here that when it comes to funds, the notion of customer encompasses the notion of investor, which is in the investment fund register. Now, given the number of intervening parties and different business relationships types which you can face in the fund industry, it may at times prove difficult to determine who should be considered as your customer. And this question is of utmost importance because it will determine on whom you shall perform your customer due diligence measures. In this respect, and we can move on to the next slide, please. If we take the perspective of a fund manager, for example, customer due diligence measures will have to be carried out with respect to all the funds that the manager has under management, which also leads to the obligation for the fund manager to identify the beneficial owners of the funds, who will be investors in the fund, but also on the initiator of the fund, on the service providers servicing the fund, such as the portfolio manager or the investment advisor, as well as on any appointed distributors. On the other hand, if we take the fund's perspective, customer due diligence measures will have to be carried out with respect to the fund manager, but also the service providers servicing the fund, such as the depository, the administrator, or the domiciliation agent, but also on the investors in the fund. This being said, it is important to remember that each party remains responsible for the carrying out of its own AML-CTF obligations. So now that we have gone through the key components of customer due diligence measures, I leave the floor to my colleague Chris, who will walk you through the asset due diligence measures, which you must also apply. Thank you.
Thank you, Melanie. Hello, everyone. Each in-scope entity should implement AML due diligence procedures in accordance with the 2004 law and must comply with its own AML obligations. For example, prior acquiring an investment, a risk scoring analysis on assets should be undertaken based on various pre-agreed parameters. Such risk scoring analysis will pave the way for a tailored due diligence on the targeted asset. Depending on the risk scoring analysis outcome, it needs to be decided whether to perform a normal, enhanced, or simplified due diligence on the targeted asset. Consequently, the information requested by the counterparty as part of the due diligence task, we can move on to, here. Consequently, the information requested by the counterparty as part of the due diligence task and relevant questionnaire that needs to be completed as part of this due diligence is adjusted depending on the outcome of the risk scoring to ensure a consistent approach with the investments. The due diligence should at least cover AML measures, but also include sanctions screening on the assets in light of the recent developments. The asset due diligence should be well documented through a report, for example, formalized and properly analyzed by the in-scope entities. As we will discuss later, if, for example, we have a real estate fund which targets real estate investments, reliance by the fund manager or by the delegated portfolio manager can be placed on the expert reports prepared by appointed property managers, subject to the relevant contractual arrangements. But we should remember that liability remains on the relying party. The CSSF is supposed to provide some guidance on asset due diligence, but there's no clear view on when it will be published. Now it would be good to discuss the roles of the responsable du respect des obligations, the RR, and the responsable du contrôle de respect des obligations, RC, in relation to AML laws in Luxembourg. Starting with the RR is responsible for overseeing the implementation of AML policies, procedures, and controls, as well as ensuring compliance with applicable laws and regulations. The RR can be the entire board of directors or other governing body, depending on the legal structure on the investment fund manager, so it can be the board of directors of the fund manager or the fund, acting as a collegial body, or can be one of the members of such board of directors or other governing body. Now I will give the floor to Julia, who will speak about the RC.
Thank you, Chris. Moving on to the RC. The RC is responsible for monitoring and reviewing transactions, conducting due diligence on customers, as previously explained by Melanie, and assessing potential AML risks. The RC identifies and investigates any suspicious transactions, maintains proper records, and escalates any concern to the RR or relevant authorities when necessary. For investment funds supervised by the CSSF for AML purposes, the RC should be mandated by the governing body of the fund. The RC may be a member of the board or a third party with appropriate experience. In the latter case, there must be a contractual relationship with the RC personally, and where the contract is concluded with the employer of the RC, the contract must name the RC. Any replacement of the RC must be subject to the fund's approval, and the RC must acknowledge its appointment in writing. Both the RC and the RR should be available without delay upon contact by the Luxembourg competent authorities. The RC typically works closely with the RR, and has the responsibility of implementing the AML policy and procedures on a day-to-day basis. Cooperation and collaboration between the RR and the RC is crucial for an effective AML framework. For example, and depending on the outcome of the due diligence and therefore any potential risk posed by the investment, the RC and or the RR might need to sign off prior to proceeding to an investment or divestment. Now that we have discussed the general obligations imposed on investment funds and investment managers, we will discuss the delegation arrangements and liability considerations.
Thank you, Julia. So the AML CTF obligations, which we just discussed and which are incumbent to you as a fund or a fund manager, including the customer and asset due diligence measures which we just covered, are extensive and may prove difficult to implement on your own. That is why, as a fund or fund manager, you have the possibility to use external third parties to carry out customer due diligence measures. To do so, you can either have recourse to the KYC checks carried out by your third-party introducer, or you can appoint a third-party service provider to carry out the KYC checks in accordance with your procedures and your instructions. It is important to bear in mind that in both of these situations, you remain responsible for the good execution of your own AML CTF obligations. That is why, when having recourse to a third-party service provider for the carrying out of your KYC checks, you will want to perform a detailed risk assessment and due diligence on your service provider before appointing it, in order to ensure that this service provider has the ability and the suitability to perform the outsourced tasks. Unlike the ongoing monitoring of your business relationship with your customers, you must also regularly control and monitor that your third-party service provider is at all times carrying out its obligations in compliance with applicable laws and regulations, but also in compliance with your internal procedures. How can you do this monitoring? Well, for instance, through the provision of sampling to allow you to verify that the customer due diligence measures executed by the service provider are appropriately done, or by carrying on-site visits at the location of your service provider to ensure the good execution of the obligations. You may also contractually require your third-party service provider to carry out regular reportings, including key performance indicators, and all of these measures will allow you to make sure that your customer due diligence measures are appropriately carried out and hence avoid potential sanctions. I now give the floor back to my colleague Chris to give you further insights on delegation arrangements and liability. Thank you.
Thank you, Melanie. In most cases, the appointed administrator is taking care of the initial and ongoing AML checks on investors, where the fund manager or the delegated portfolio manager is responsible for doing the AML due diligence on the assets to be acquired by the fund. Funds or fund managers must carefully select and monitor the third-party providers to whom the task of performing AML checks on investors, assets, other service providers is delegated to, ensuring that they have robust AML compliance systems in place. AML checks must be properly documented, and the relying parties must perform their own analysis on the documents received from the delegates. They must ensure that the relevant AML controls have been duly carried out, which is particularly necessary in case of on-site visits by the CSSF. Therefore, adequate clauses in the relevant contractual agreements between them should include the relevant provisions for ensuring that monitoring. In other words, the relying party should have contractual arrangements with the third party that outlines the means for monitoring the third party, the flow of information between them, as well as the freedom to the relying party to have immediate access to the AML documentation gathered by the third party on the fund's behalf. While relying on third parties can be inconvenient, it does not absolve the relying party of its own obligations. It's crucial to highlight that Luxembourg law holds the relying party responsible for any breaches by the third party.
Thank you, Chris. I just want to, as a conclusion, remind you that the risk-based approach is really an essential component when looking at AML CTF obligations. And I would say adapting the extent of measures that you carry out is really dependent on the level of risk that you apply, not only in relation to your customer, but also on the asset side. And there's no fit-for-all solution. So looking, I would say, on the asset side and appreciating or assessing the risk that presents your asset is going also to determine what you are going to do in terms of due diligence in relation to that asset. How far are you going to go in relation to that specific asset? Of course, this depends on the nature of the asset in question and therefore the level of risk of that asset in question. And I know that there's a lot of uncertainty in relation to asset due diligence because there are no specific, I would say, detailed measures either in the law or in the CSSF regulation or the ALFI guidelines, but it's also due to the fact that you have that concept of risk-based approach, and you should rely on that concept and use that concept. Also, to end on another note is non-compliance with AML CTF obligations may lead to sanctions, and you need to take into consideration the various sanctions which can apply. First of all, criminal sanctions in case of money laundering per se, as set out in the criminal code, with prison sentence and or fines. Criminal sanctions again, but this time for non-compliance with your professional obligations as set out under the AML law, with fines again and up to a certain amount. Administrative sanctions, which will be levied by your supervisory authority. And for example, if we're looking at the sanctions which can be imposed by the CSSF, a warning, a reprimand, a fine, and I'll give you a couple of examples just in a few moments. And I would say also very important risk, which is your reputation risk. And let's not forget the naming and shaming. So the obligation for the CSSF to publish on its website sanctions which are levied by it. And the publication will contain your name unless the CSSF chooses, so to speak, to do so on an anonymous basis, because there are reasons which can justify the publication on an anonymous basis. So if we're looking at the year 2022, and just to give you a little bit of numbers here, the CSSF imposed 43 sanctions, out of which 19 related to AML breaches. And out of the sanctioned entities, 13 were investment fund managers. The maximum amount of the sanction was 1.5 million, the lowest 5,000. Main reasons for investment fund managers to be sanctioned was due to non-compliance with the deadline to provide the AML questionnaire. So compliance comes at a cost, but the cost of non-complying is higher. And there are measures in order to be taken to avoid these risks. Avoid to be in a position where you will receive a sanction, in particular from your supervisory authority. So your policies and procedures should be in place, in writing, updated, reviewed, understood, and applied, because there's no point in having a perfect document which contains all the requirements as set out, in the law and the regulation, grand ducal regulation, etc., if you don't apply your policy and procedures. Your operational processes and systems should be implemented and tested. Outsourcing arrangements should be in writing and monitored. You need to document and evidence the measures carried out. There's no point in saying, well, I've done my due diligence, if you don't have the evidence demonstrating that you did effectively carry out that due diligence. And finally, don't forget to formalize and have approval processes. So those are just, in a very short time, a couple of tips, a couple of elements to be borne in mind, but there are many others that can be done. So that's it for us today. Thank you very much for joining us, and We are looking forward to another webinar on this fascinating subject of AML. Thank you and have a nice day.